Order. Welcome to meeting number 44, the House of Commons Standing Committee on Justice and Human Rights, pursuant to order of reference of November 24th, 2022. The committee is meeting to begin a study on Bill S4, an act to amend the Criminal Code and the Identification of Criminals Act, and to make related amendments to other acts, COVID-19 response, and other measures. Today's meeting is taking place on a hybrid format pursuant to House Order of June 23rd, 2022. Members are attending in person in the room and using the Zoom application. I'd like to take a few moments for the benefit of the witnesses. Please wait until I recognize you by name before speaking. For those participating via video conference, click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either Floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed to the chair. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raised hand function. The clerk and I will manage the speaking order as best as we can, and we appreciate your patience and understanding in this regard. On our agenda today, we will be proceeding with Bill S4, first to hear Le Barreau de Quebec, and right after, as per motion adopted last Thursday, to do the clause-by-clause study. Also, we need to reserve a few minutes to complete our review in camera of the draft report on the subject matter of C-28. As all of you know, we have to report it before December 16th. And before Mr. Fortin asks me, I believe they've all been tested. Their mics, the witnesses have been tested?
The two first witnesses.
Okay, the both witnesses have been tested for sound quality. So back to our first item of business today. We will have from Barreau de Quebec, Catherine Claveau, Batonnerier by video conference. We have
Bonjour.
Nicholas Legrand-Allery, lawyer, Secretariat of the Order and Legal Affairs, also by video conference. So we welcome you to the committee and thank you for accepting our invitation on a short notice. You have the floor for 5 minutes.
Monsieur le Président.
Mr. Chair, members of Parliament, I'm introducing myself once again. My name is Catherine Claveau, Bâtonnière du Québec, and I'm accompanied by Nicolas Legrand-Allery, who's a lawyer, Secretary of the Order and Legal Affairs. We thank you for inviting us here to speak on S4. For more than 2 years, the pandemic of COVID-19 has created some real challenges for the legal system. And we have been able to adapt to those challenges, all the while meeting and respecting the Charter of Canadian Rights and Freedoms. This bill, S4, is intended to modernize criminal procedure and also to allow large courts to benefit from this. Like many other administrations of justice, we in Quebec have had to innovate to meet the needs and innovations of COVID-19. In this context, the impact of the changes will be very important. While it is true that the Barreau du Québec is certainly able to support change in justice, we do want to respect the criminal justice system in its entirety. And the bill, as you know, it deals with cases that can be done on summary conviction or through indictment. But it is through a trial that we evaluate the instance, and that is something that has to be seen as a norm and not an exception, although, of course, there are many technological means at hand. We have to look very carefully at the principle. We are concerned about the effect of video conferencing on the ability to deal with the witness. Very often, it is emotion and details that can convey information. The virtual character of evidence that is given can particularly have an effect during examination and cross-examination. Sometimes it's just a simple note that's given to the lawyer or a look from the judge or from a witness that can get the counsel who is conducting the examination off track. And the possibility of having representatives, particularly in the case of the non-represented parties, this can be a problem during a trial. The proximity of the layout of the courtroom is very difficult to determine, but we do feel that insofar as possible, evidence should be given in person. And also there is the issue of professional accountability between a lawyer and his or her client. They have to be able to preserve the confidentiality of their lawyer-client privilege when they do speak and do dialogue. And also, we do not want this bill to have any detrimental effect on people who live in rural or faraway areas. So in Quebec, very often we deal with what we call variable geometry because of the various regions in Quebec and the issues that arise from self-represented accused would really come into play here. Briefly put, we feel that the new status given to video conferencing in the criminal code may well set a precedent for a two-speed justice system. And also, the Barreau feels that this new article in the criminal code, which requires an accused in custody to appear in a video conference remotely, is something that could be a problem given the way in which it is drafted, and therefore we recommend that it be deleted. In actual fact, what we want is this, that parties should be able to proceed with their proceedings in person whenever it is possible. We want to have a fair and just trial that is there for every person involved. And that is what we at the Barreau du Québec are hoping to discuss with you today. We thank you for hearing our thoughts today, and we are here now to answer your questions. Thank you for your attention.
Bravo. We'll now go to our first round of questions, and we'll begin by Mr. Caputo for 6 minutes.
Okay, merci, Madame.
Thank you very much, Madame Claveau.
French is not good enough to address you in French. Now, I have some questions here for you, and please don't take these as me being adversarial. I approach these questions in a spirit of dialogue and in a desire to learn a little bit more. Now, I'm going to start with one area that's a bit contentious in my view, and that is testimony by video. And I really want to get your opinion on something here. Are you familiar with Section 486.2 of the Criminal Code? I don't expect you to know it off the top of your head, but no? Sorry?
Si vous me permettez.
If you would allow me, I would like to pass the floor to my colleague who, for the substantive questions, will speak on behalf of the Barreau.
So Section 486.2 actually, what it says in a nutshell is that when there's somebody with a disability or you have a child, for instance, I believe it's what we call a presumptive application. I'm not sure what the French equivalent would be, but the judge is presumed to grant the order that person can appear outside of the courtroom for testimony, okay? And in that case, this is often when we're dealing with sexual offenses against children. So I'm just trying to reconcile how, in this instance, Parliament has said we're okay with a child testifying by video and presumed to testify by video, or a person with a disability. Do these credibility issues, do they apply equally when we as Parliament have already conferred this power, this authority on a trial judge to allow a child to appear by video in any event?
Alors, bonjour, merci.
Thank you very much for your question. I think that without getting into examples about evaluating the credibility of witnesses, I think we have to look at the issues. And these are issues that apply to victims or their witnesses. We're talking about a video conferencing system where very often the bandwidth may not be adequate. There can be the sound can cut out, and there can be a variety of difficulties. So it's not about the credibility that we are so much addressing, but we are really speaking to issues about the administration of the testimony itself. The criminal code that you referred to it deals with CCTV appearances, and very often you can have a sexual accused but for that purpose, that is CCTV. But very often you have the issue of remoteness, and you can also have the issue of technology itself. So the accused and the witnesses may well have to be in the same room for their appearance, because the Zoom platform that is used by the court can not be appropriate if you have to separate them at times.
That answer, I'm just going to clarify, sir, this. Do I have it right then that your issue comes with the technology gap then and not in the credibility, that the evaluation of credibility? Do I have that right?
Je dirais que c'est un...
Yes, I'd say it's a little bit of both, but there is an issue with respect to credibility, with respect to the notion. You talked about technological gap. That can create difficulties in terms of credibility, but it is really with the technology.
Okay, because to me that seems like an issue for the that comes within the proper administration of justice, as in when we have courts that are going to be conducting trials, the expectation is that the facilities are up to par. So I'm just questioning whether, as Parliament, we should be considering the provision of technology when really that should be a given in the circumstances, should it not?
Tout à fait.
Oh, yes, you're quite right. That's one of the issues, though, because what the Barreau has found is that you can agree with the provisions of the bill, but say here in Parliament, but very often it has to be implemented in such a way that it can be functional, that you can ensure that you have these tools at hand to be able to render justice. Perhaps it's the role of Parliament to set out some criteria in an assessment where they would be able to deal with technology.
So hypothetically, if you know, a high definition feed could be provided, would you be okay with that?
Au niveau de...
With respect to the administration of the testimony itself, I would say yes. But you have to also consider the counsel for the accused. You may have people who are remote, very far away, not in the same room, and you want to have efficient communication between the accused and the accused representative, his or her counsel. And so there has to be a set of circumstances that have to be in place, and that really is a technological issue.
I'm out of time. Thank you.
Thank you. Now we'll go to Ms. Diab for 6 minutes.
Merci beaucoup.
Thank you very much, Mr. Chair, and welcome to our witnesses today. Thank you very much for being here today.
So the issue is one that I am a bit familiar with from my days in my own province of Nova Scotia, La Nouvelle-Écosse, and particularly, quite frankly, the last couple of years with the fact that we've had COVID. I know there's quite a bit of investment that has happened in the justice system with regards to technology, video conferencing, and all of that in courts. May not be enough. I would say to you, it's probably never enough. There's always more work to be done. But I know we've moved a lot in the last 8 years, 6, 7, to make it very friendlier or much more friendlier for the opportunity to give video conferencing and so on when that is the most when witnesses, not witnesses really, I believe the bill is that parties have to agree to it. So this is an option. It is not a requirement in the bill. So I guess what I would ask you is, and again, just like my friend or my colleague there, Mr. Caputo, in the spirit of dialogue as well, for me, some of the changes here seem to be taking us backwards from where I think we have tried in the last number of years to sort of modernize a little bit the court system, and which is a good thing. Can you comment on that, and how do you feel about that? And I guess, I don't know if you're aware, but do you feel that other barrister societies across the country would share your view? I certainly haven't heard that, but I would like to get your feedback.
Oui, merci.
Yes, thank you for the question. We're not aware of the position of other barrister societies in Canada. But what I can tell you is we share the ultimate wish of this bill to improve the administration of justice, to improve the wheels by which it is delivered. We've had a rather strong year of modernization in the courts, and it was even more accelerated during the COVID pandemic, really, because it was something that had to be done. And once again, we're not opposed to what's in this bill, but we're just wondering and concerned about some aspects that would become permanent, the aspects that were used during the pandemic. What we would propose would be, say, to take a step backwards and have a good look at those measures from the procedural perspective and from the perspective of the guarantees in the Charter. That is more or less why we are here today. We certainly understand the goal of the bill and support the overall goal of the bill itself. But you said that it is an option. It remains an option. And yes, it has to be based on the consent of the parties. And the judge has to justify if there is a refusal. So video conferencing might become over time the norm and not the exception.
Okay, merci beaucoup.
Thank you very much for your answer.
Je comprends vos...
I certainly understand your hesitations, but I think I'll express myself in English.
The good will outweigh the bad, in the bill that is currently proposed. And my understanding is, the bill came forth as a result of Canada working with provincial and territorial ministers across the country, and I believe it has also gone to the Senate, who probably did their job as well, and it's come back before us. And certainly the reality that I'm aware of on the ground, when I was looking at the criminal justice system in my own province, is many were, and I mean, crying is a hard word. I don't know what English word to use, but really were advocating and really looking, to have those types of opportunities, if at all possible, because it was just so difficult for so many to be appearing, depending on particularly, if people are in custody. I mean, there's many, many situations. And again, it was an option that is available. So anyway, that would be my comment there. I guess was there any other sort of concerns? And you may have talked about that, Madame Claveau, but I'll ask Monsieur Legrand-Allary, is there any other big concerns that you would have that you haven't sort of noted yet?
Very quickly, 10 seconds, please.
Rapidement, je dirais.
Well, I'd say that there are issues. You have to remember that these are fundamental rights under the Charter, and so you expect that someone should be able to go into a hearing room, into a courtroom, and that a procedure should unfold the way it was intended to be. And I think we have to look at that issue.
Thank you. Thank you. Now we'll go to Monsieur Fortin for 6 minutes.
Merci.
Thank you very much, Mr. Chair. Madame La Bâtonnière, Mr. Allary, thank you so much for being with us today. And as my colleague, Madame Diab, has said, this has been before the Senate. This bill has been before the Senate last spring. Parliament has been quite rigorous in its scrutiny. But we also want to scrutinize the bill. And so I'm very happy to hear you speak today. That is, there's nothing totally major with respect to S4. I understand the issues that you have expressed, and many other witnesses have said that they want a more modern system of justice. Video conferencing is a tool that we can use when need be, but probably when need be is probably the key words here. Are probably the key words here. If you look at recommendation 3, section 715.3, which allows them to use that in a conference without necessarily obtaining the consent of the accused. Do you have any issues with that if there is no amendment to that particular part of the bill? Yes, well, thank you for your question. There is an issue with respect to the provision 715 or 241, if memory serves me well. It was brought up in previous questioning. The video conferencing has always been presented as one option amongst others, part of a toolbox. And if the judge determines that it has to be, or if it's refused, it has to be justified. But the video conferencing can be imposed. And there are issues. I touched on those issues earlier in an earlier response. But there should be the possibility of the lawyer being able to provide adequate counsel to his client. When the lawyer is in his office and the judge is in a courtroom or in some other room, and then you have the person in custody somewhere else, it is quite difficult to have the lawyer counsel his client adequately. So I just want to sound a note of prudence with respect to that. Video conferencing should be voluntary. So what I draw from this, insofar as this is concerned, it is the judge who is looking at the procedures, who is presiding, rather. The bar of Quebec says that this is adequate if the judge is there and if the lawyer can consult his client easily. But if that is not the case, then there is a certain risk with respect to justice and the administration of justice. Yes, I would agree there are some risks. You can always make the professionals around the table aware of the fact that you can trust the counsel for the Crown, but you have the accused when the accused has been detained for a hearing date that is later postponed, or if the whole management of the procedure is long. So there is some greater need for the accused to be present. And there are other measures, of course, that exist in the criminal code to ensure the presence. Maître Allard, I don't have much time, so I have to move on. 72.1, when you say where it specifies that the accused should have access to legal counsel, what is the difference between that and being represented by a lawyer? I think there's some confusion with respect to the terms. When a person is represented by a lawyer, if you look at the words of the expression, it could be, being capable of calling the emergency line for the lawyer, or standards that have to be evaluated. Even though terms and the words that are used, you have to be very careful. Yes, but the accused who has access to legal counsel does not necessarily have to bring in a lawyer. But if he's only speaking on the phone, particularly when there is an appearance, either video conference or in person, it could, I believe, become a very problematic process. I'm being told that there are 30 seconds remaining in my time. Do you have anything to say about what I've just said? Well, the fact is that it depends on the scope of the motion. Does that include a telephone line, an emergency line with immediate access to legal counsel, or is it just something that is as general? And the fact that that term is used, and it's not used systematically everywhere in the Act, can give rise to problems. Thank you.
Thank you, Mr. Fortin. Now we'll go to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair, and I thank the witnesses for being with us today. Madam Diab started a line of questioning I want to follow up on because I think if I read the bill correctly, in all but one section, using video or audio conference requires the consent of both the prosecutor and the accused. And I think you rightfully identified in Section 46, the new 715-241 has one exception. If someone is in custody, they can be required to participate by video conference if no witness testimony is being taken and if they have access, private access to counsel. Is that also your understanding of the bill?
Yes, indeed. That is the exception where you can oblige somebody. It is 715.241. That's the new one. But on consent, there are criteria that have to be respected.
And so your broader concern that appearance by video conference might become the rule would seem to me to be mitigated by the fact that everywhere else it requires consent of both the prosecutor and the accused. Would you say, you're obviously saying that's not the case, but it seems to me that that would mitigate against this becoming the common practice.
I'd say that you can recognize that it is a procedure that exists on confrontation, but if you look at 715-2401, where the judge has to put in writing the reasons why he refused the condition, you have to consider those grounds in the file, and you therefore start to move towards an application that would be one of consent, but there are consequences. But in addition, perhaps the most important point is this. Once again, we're not against video conferencing, but we want it to be done properly within the rules. And every guarantee that is offered technologically or under the Charter has to be there. It has to be ensured. Because it might be easy to make certain measures that were there temporarily because of COVID permanent, and we don't want necessarily just to be thinking of statistics. We want to be able to ensure the administration of justice.
Thank you very much. With your concern about the technical aspects of video or audio conferencing and the conditions of substandard connections sometimes and all those things. Also in Section 46, there's a Section 715.23 called Considerations, Appearance by Audio Conference or Video Conference. And what that section says is the court must be of the opinion that the appearance by those means would be appropriate, having regard to all the circumstances. Do you not see this as a protection that the court can use if the technology is inadequate?
Oui, c'est effectivement.
Yes, of course. It is a measure. It is a criterion that is very significant. And if there's any difficulty whatsoever. But once again, I know we've spoken a lot about technological and technical issues. But the physical organization is important as well. The presence of people in a room, the layout of the room, a possible issue might be that trials in major cities are in person, but in the regions very often they are still remote. And it could be that there would be consent only for the purposes of efficacy and efficiency. I just want these particular issues to be considered, but we want to have the guarantees, the fundamental guarantees, respected in all circumstances.
I would say very clearly that I share those concerns, and I think people around the table know that I'm no fan of virtual proceedings of any kind. But I feel like there are some protections here through the consent and the judge's ability to decide that the circumstances aren't appropriate. So, Mr. Chair, I'll conclude my questions there.
Thank you, Mr. Garrison. We'll now go to our next round for 5 minutes, beginning with Mr. Brock.
Thank you, Chair, and thank you to the witnesses for your attendance today. I'm going to comment, I'm going to question you with respect to an article that the Bureau prepared in April of 2022. It's titled Comments and Observations from the Bureau de Quebec. And in particular, you state in the paragraph, the Bureau would like Parliament to draw a more complete picture of the real impacts of the proposed video conferencing provisions, particularly on the objective of searching for the truth in criminal trials. Given the time constraints, we are not able to undertake an in-depth analysis of the subject, but we invite Parliament to consider this in its study of Bill S4 and be more careful with the proposed new video conferencing system. So with the limited amount of time that I have, I'd like to give you an open floor to provide a little more color with respect to that statement from either of you.
Thank you for your question. There are issues that have been brought up by the Barreau du Québec with respect to the administration of justice, measures that deal with the collection, with data collection, statistics that may well have been abused by other fora, and what we want to do is to carry out a study. We want to obtain data. We want to obtain the figures to determine the impact. We want to be able to identify the means of applying these and how the lawyer can, say, for example, speak with the client. Is it through a Zoom link or not? The right to a fair trial, and also within Canada in its remote areas. I think it would be very interesting if Parliament were able to take a close look at those issues, assess the consequences, and have a clause in the bill, say in 5 years, if it's when it's renewed and reviewed, just to be sure that the measures that were proposed and then were put in place following the COVID pandemic are in actual fact doing their job and are effective.
Virtual hearings, if open to the public, can ensure the continued respect of the open court principle, but also affect the privacy interests of participants. While individuals can watch in-person court proceedings, few do, and virtual access may increase public viewing substantially. Remote appearances also include the possibility of live streaming, screen grabs, or recordings which can then be distributed or posted online. 2 questions. How should the open court principle and privacy interests be balanced in virtual hearings? And secondly, what impact could public broadcasting have on witnesses, particularly in cases of sexual assault and other more sensitive matters?
Merci pour la
Thank you for your question. This is one of the very most important issues with respect to recommendation 2 that we in actual fact made. Publicity is an issue. There is this issue that is linked to technology. If you move ahead with the video conferencing and the public could have attended in person sitting in a courtroom, that public that could have done that has been prevented from doing so. And also, as we are participating today by video conference, that perhaps there were people who would have wanted to attend in person, but the attendance must be done through a video link on a screen. And that's not the case when you're in a courtroom per se. With respect to your second question, with respect to the victims of sexual, say, assault, the public can be excluded. The judge can make a decision and ensure that there is no issue at that time.
Thank you.
Thank you, Mr. Brock. We'll next go to Madame Briard for 5 minutes.
Merci, monsieur.
Thank you very much, Mr. Chair. Thank you. Hello to our 2 witnesses, and thank you for being with us today. You mentioned at the outset that the pandemic created issues, but it was necessary to move on with the modernization of the criminal system. We know that there has been sometimes some hesitation in terms of changing procedures, legal procedures that are long-standing and are well-known. This has been touched on a bit, but during the pandemic, there was a very positive effect of the changes. There were new methods introduced, and what I'm referring to is in a previous study, we heard somebody say that they had to drive a long distance, take a hotel room, and then turn up at court the next morning, and all of this. So if it were possible to do that by video conferencing, that person would, or the victim and the victim's family would have been able to avoid a long trip and spending so much money. That is something in the changes that were proposed. I'd like to hear your opinion about that. I will begin, and then perhaps my colleague can chime in. We agree. I think we have to agree that for any hearing, any provisional hearing where we don't need to establish the credibility of witnesses or anybody else for that matter, it's all right that should be a video conference. That is an effective way. But when we at the Barreau du Québec intervene and hold up a red flag is when we wonder whether or not, and this is our concern, we wonder whether or not evidence given by one of the parties might tip the scales. My colleague? Well, yes, Catherine. I think Maître Lavaux has pointed out the difficulty. In the cases that you have described, we'd certainly never be opposed to such an example to prevent witnesses from unnecessary travel and expense. Lawyers will get together and they will try to arrange it with the court so that those options are available to prevent travel and costs, of course, if it's possible. But once again, when there are basic issues, for example, testimony, evidence, perhaps, as my colleague said, that's where we raise the red flag with all the respect that we have for you. Thank you. The Chief Justice was last week stated that there were several trials that had been delayed and even cancelled. Do you think that S4 would have helped to avoid this situation? Will it avoid delays, and would it not help the courts? Well, certainly. In terms of hearings without witnesses that avoid travel, but it would require a minimum of management to coordinate all of that, and certainly it wouldn't in itself alone be sufficient to settle all the problems that exist in the court system. For example, the lack of people in the courts. No, I don't think I have to add anything to what was said by my colleague, but it's not a panacea. Thank you. We talked about the credibility of witnesses. I'd like to hear your opinion now about translation, because we know that it's very much used in courts, and perhaps in terms of the court interpreters, when it's in video, can that create difficulties for the interpreters for the proper understanding of all the parties? We don't have any data about interpreters or translation or court interpreters, just in general, the note-taking that is done. There are some issues with respect to note-taking, with respect to the recording of the debates, and with platforms like Zoom, Teams, or others, there can be problems. For example, that they can cut out, they can even crash, and that brings up difficulties for those people who are in the courtroom. Well, just to talk about that to our interpreters who are here with us today.
We'll go to our last round of questions to Mr. Fortin for 2.5 minutes.
Merci, Monsieur.
Thank you very much. Isn't it 3 minutes, Mr. Chair? Just 2.5? I'm not going to fight over 30 seconds, but to our witnesses, either of our witnesses, 715.241 is the section where the court can require the accused to appear without having to obtain his or her consent. Now, I'd like to hear you both or either of you about this. Could that not be a subject for appeal with respect to a fair trial? Because personally, I wasn't able, say, to present my arguments before a court. And so what was the impact? What would you say would be the impact on the confidence and trust that the general public has in the administration of justice if problems like this arise? Yes. If the absence of the accused is a definitive element in the trial of, say, for the lawyer or for the defendant or the prosecutor, or if that could give rise to an appeal, perhaps so on that basis. But if it is just to set the dates, say, of a future hearing, perhaps it might be better just to do this type of thing remotely. But if it has a direct impact on the accused, I think there you have to look at the importance of maintaining consent as the criterion. About that, then, in your recommendations, you talk about the problem of the uniformity of the administration of justice, because really there are two different realities, completely different realities in some areas. When you spoke to the difficulties in the regions, do you have any more specific details about this problem in the Barreau? Do you have a breakdown on a regional basis? Thank you for the question. Unfortunately, and we are very sorry about this, we have asked for data. It is part of something we are asking for from the courts. We want to be able to have the ability to ensure that all actors in the administration of justice system have the tools that they need at hand. We can't give you this type of detail, but we would like to be able to have it to allow us to come up with solutions to improve the administration of justice. Thank you to our two witnesses.
Christmas, you got your 30 seconds that you had requested, Monsieur Fortin. I want to thank all the witnesses for your testimony. It's been very informative. We're now going to switch to our clause by clause. So we'll just have a few seconds to transition to some of the other video conference guests we have and have our in-room guests to come forward as well. Thank you. So we'll resume. We have, we'll be doing clause by clause. We have from the Department of Justice, we have Matthew Taylor, General Counsel and Director of the Criminal Law Policy Section. We also, do we have anyone online, Mr. Clerk? We have Mr. Normand Wong, Senior Counsel, Criminal Law Policy Section by video conference. That's it. So I don't know, you can put him on the screen if he needs to be, but it doesn't really matter. Oh, when he speaks, okay. Some considerations, so I'd like to provide members of the committee with some instructions and a few comments on how the committee will proceed with clause by clause consideration of S4. As the name indicates, this is an examination of all the clauses in the order in which they appear in the bill. I will call each clause successively, and each clause is subject to debate and a vote. If there are amendments to the clause in question, I will recognize the member proposing it, who may explain it. The amendment will then be open for debate. When no further members wish to intervene, the amendment will be voted on. Amendments will be considered in the order in which they appear in the bill and in the package each member received from the clerk. Members should note that amendments must be submitted in writing to the clerk to the committee. Now, the clerk has advised that if there was any amendment resulting from the testimony we just heard, and you can still send it to the clerk in writing, and we shall consider that. The chair will go slowly to allow members to follow the proceedings properly. Amendments have been given an alphanumeric number on the top right corner to indicate which party submitted them. There's no need for a seconder to move an amendment. Once moved, you will need unanimous consent to withdraw it. During the debate and amendment, members are permitted to move sub-amendments. These sub-amendments must be submitted in writing. They do not require the they do not require the approval of the mover of the amendment. Only one sub-amendment may be considered at a time, and that sub-amendment cannot be amended. When a sub-amendment is moved to the amendment, it is voted on first, then another sub-amendment may be moved, or the committee may consider the main amendment and vote on it. Once every clause has been voted on, the committee will vote on the short title, the title, and the bill itself. If amendments are adopted, in order to reprint the bill may be required so the House has a proper copy for use at report stage. That report contains only the text of any adopted amendments as well as any indication of any deleted clauses. To begin the clause-by-clause study, before I call Clause 1, in the interest of time, given that there are no amendments to most clauses, I would seek the unanimous consent of the committee to regroup clauses for the purpose of voting, starting with clauses 1 to 38. We would then debate the amendment on Clause 39 and group subsequent clauses as we go along. Is there a unanimous consent? Yes? Okay.
Yeah.
Okay. Thank you. If so, shall Clause 1 to 38 carry?
Yes.
Yes. Thank you. Let me go. Clause 39, we have block amendment 1. Shall block amendment 1, do you want to speak to it? Sure, Mr.
Merci, Monsieur le Président.
Thank you very much, Chair. Listen, the amendment BQ1, like BQ3, go with the substance is a BQ3, really. What we want to do is not abolish. No, it's BQ1 and BQ2 that go together. We wish to delete lines 8 to 13 on page 22 with the goal of reflecting the recommendations of the Barreau du Québec with respect to the issues surrounding 715.24, because we think it's a bit counterproductive in terms of the appearances. So that, in a nutshell, is why we have moved to BQ1 and BQ2. I think that I'm not going to add to what was said by the Quebec Bar earlier. Our witnesses expressed their concerns very clearly. Obliging somebody who is in custody to appear on a video conference that opens the door to possible appeals, and it also erodes trust in the administration of justice, and perhaps minimizes the protection that is afforded by the Charter of Rights. So, I mean, if they are virtual and they agree to that, well, there's no problem. But if the judge says, and we have a self-represented person, that is to say, the accused has no legal counsel, so a lawyer could come a month later or 2 months later, and say, my client didn't concede to that. He didn't have the opportunity of speaking to the court because he was being detained in custody. So S4 is a wonderful bill, and it is modernizing proceedings, but I think that it does so respectfully in terms of the rights of all the parties. But it is this one instance that is a real problem for me, and I think that we have to look at it closely. And that is the thinking behind BQ1, which would substitute the notion of concordance on page 22, I believe it is. No, line 22 on page 18, where you refer to sections 715.24 to 715.24 by audio conference or a video conference. So that is what we are seeking.
Thank you, Monsieur Fortin. Now to Mr. Anand-Singari.
Mr. Chair, I'd like to get a sense from Mr. Taylor as to what the impact of, and I'm going to just say we work with Clause 39 first, and then when we have a discussion on 46, his comments on Clause 46.
Thank you and good morning. I'm hoping someone could provide me a copy of that motion because I don't have the BQ motions. I gather it relates to Section 650 of the code, but if I could have a copy, that would help.
Yeah. Would it be? Okay. It's only in the English version.
Microphone. Microphone, please.
So this to me looks like a consequential amendment to a other substantive amendment that will come later, and specifically to remove reference to certain proposed sections in the bill. So if I understand correctly, the concern relates to the remote appearance provisions, so this clause and clause 46 of the bill. And maybe I can start with some general information. The first thing I would point out to the committee is clause 45 of the bill reenacts a provision that already exists in the criminal code, or would reenact a provision that already exists in the criminal code, which states the principle that, as a general matter, proceedings would be done in person. So that's the starting point. And then what Clause 46 proposes to do is to consolidate and clarify a bunch of different rules that already exist in the criminal code with respect to remote appearances. And so in effect, when I say consolidate, there are provisions, for example, as is Clause 39 in Section 650 of the Criminal Code. There are provisions in other clauses of the bill that are being opened, such as Section 537 of the Criminal Code and Section 800 of the Criminal Code that all deal with the rules around remote appearances. Bill S4 doesn't propose to change those rules. So to the extent that an individual can appear by video conference, S4 doesn't propose to change that. If I understand as well the concern around the requirement of an accused to appear in proposed 715.241 in a situation where there isn't consent provided, that is simply a reenactment of existing rules. It doesn't change the law in that respect. So the goal here is really to ensure that if an individual in custody is going to appear in a proceeding, that the court ensures that they have access to legal advice before they do so. So I know that's a lot of different pieces of information, but I think the main point to convey is that S4 really seeks to consolidate and clarify existing laws around remote appearances.
Do you have anything else to add, Mr.
Yeah,
Nunzio?
so for the purpose of this, discussion, should we have the discussion on clause 46 before 39?
You can have the discussion, but we have to go to that at that time, so. Yeah, we would have to get unanimous consent to discuss that before. We have discussed, yes? Okay. We have consent to discuss 46, if you want.
Yeah. So, and thank you, Mr. Taylor, for that clarification. And I think just based on what you've said, also based on what the witnesses have said, I think it's very clear that as for the scope of it is very important, and it does really make, in some circumstances where all parties agree to these proceedings, remote proceedings, available. As we know, some of us have practiced for some years in courtrooms, and we know that at some points access to witnesses can be difficult. And I think there have been a number of examples that were cited. I think Ms. Briere brought one up as well. I also think it's important that the Criminal Code 715.24 is not a new provision. It would merely reenact a new part of the Criminal Code to clarify and consolidate the provisions on remote proceedings. It would also be preferable to have these existing powers located in the part of remote proceedings because it ensures that court is required to take into consideration the factors as set out in 715.23, and this recommendation would also undo what are longstanding court powers. I understand it goes back to 1999. In some cases, some are from the mid-2000s, and for this reason, we will not be supporting on 46 and subsequently on 39 as well.
Thank you very much, Chair. I just would like to speak to the witness. The problem that I have is that, and I quite agree with what my colleague has just said, I quite agree with what the witnesses have said as well. So I'm wondering if there won't be some problems. 715.24 is okay because the court can allow the accused to appear by video conference, but it says it can. It says in English, the court may allow, but in English it says are required, and in French, exiger is the word that is used, and that's where there lies the rub. So it seems to me there is this new way of proceeding where the court can require a witness. And there's no issue with consent here. He's being asked to consent? No. I read the court may allow versus the court may require. And that is the problem. Could the witness or someone else answer this issue? Is it judicious? Is it reasonable that a court can can impose this condition? And I think this is what the Barreau was getting at, and this is what is bothering me.
Mr. Moore? Mr. Moore,
Thank you,
please.
Chair. And yeah, not to answer Mr. Fortin's question, but discussion on these two provisions, Clause 46 and then by extension, Clause 39. I listened to we had a very abbreviated opportunity to study this bill, of course, but it has been in the Senate. So I looked at some interesting Senate testimony. We did have the benefit of hearing from the Quebec Bar this morning. And I think anytime there's legislation that's, some of this, there was a long-standing need pre-COVID. Some of what we see in S4 is certainly a reflection of being in a pandemic time when there was major limitations on in-person meetings and a desire to be able to do things differently in every aspect of our lives, including the judicial. I look at the amendments being put forward by Mr. Fortin and as well the CPC amendment. I know there's probably some conflict between the two, but I look at that as maybe reflective on the fact that we are past the COVID pandemic lockdowns right now, and while there are many aspects that are very important in C9, there are aspects that or should say S4. There's aspects that I think we may want to put the brakes on a little bit, as certain presumptions that are included. And I can tell you today I have the unique opportunity, just because of a canceled for no apparent reason Air Canada flight, that I'm participating in this meeting virtually. And having normally I'm in person, you're major limitations on the ability to understand what's happening in the room, get a perspective on how people are receiving what is being said or isn't being said, all nonverbal cues that one might get. So that's lacking in any kind of virtual meeting. And the most important, the highest level, is going to be a judicial proceeding that where someone's life, possibly their future, hangs in the balance, and where victims are being asked to participate in a system that all too often re-victimizes them. So without belaboring the point, I think that I think there's some reasons that I'm very receptive to the comments made by the Barreau de Quebec, as well as the amendments that have been put forward, and I think I'm inclined to support them for sure.
Thank you, Mr. Moore. Mr. Garrison?
Thank you, Mr. Chair, and I thank Mr. Taylor for the reminder for all of us that the presumption of the criminal code is that appearances will be in person, and what we're dealing with are exceptions. I don't share the optimism others have about either this or future pandemics. And I also have a great deal of pessimism about the impacts of climate change as it affects all of our systems. So I think having the exceptional provisions in place in advance will serve us well as we head into the future. I'm convinced that the requirement of consent by both prosecutors and the accused provides sufficient protection. Admittedly, there's one circumstance where that doesn't apply. But I'm also reassured by the section on appearances by audio conference or video conference, where it says the court must be of the opinion that the appearance by those means would be appropriate, having regard to all the circumstances. So generally on amendments to S4, I will be voting against them. I think the protections are, the existing protections are simply being reinforced here, and we are creating some exceptional circumstances to deal with the world we live in today. So I will be voting against the amendments.
Mr. Nansingari?
Mr. Taylor. Just wondering if Mr. Taylor could give us a little bit of clarification on the language difference that Mr. Fortin had identified.
Sure. Maybe if it's okay with you, Mr. Chair, what I would propose to do is just quickly walk through clause 46 and draw your attention to where the proposals in the bill correspond with equivalent provisions in the criminal code. Because it is a large clause. So proposed section 715.23 is drawn from the equivalent provision in the code already, and really, I think, has already been spoken to earlier today, provides a set of circumstances or criteria that a court must take into consideration when determining whether to allow remote testimony. Proposed section 715.231 requires the consent of the prosecutor and the accused for participation in preliminary inquiries, and that is drawn from existing section 537(1) of the criminal code. The next provision, 715.232, deals with summary conviction proceedings, and that is drawn from subsection 650(1.1), and requires, again, the consent of the accused and the prosecutor in cases where the accused is not in custody, or consent of the accused where they are in custody. So there's always that check and that balance that exists. There's also a corresponding section 802.1 in the current criminal code that this provision is drawn from. 715.233 is also drawn from 650.1.1, and this is the provision that governs remote appearances in indictable prosecutions for indictable offenses, and again requires the consent of both the accused and the prosecutor. Proposed section 715.234 dealing with pleas, guilty pleas, again requiring the consent of the prosecutor and the accused, and is drawn from existing section 606 of the criminal code. Sentencing, 715.235, again consent of prosecutor and offender, and drawn from section 650 of the criminal code. Proposed section 715.24 is a kind of a residual catch-all provision that addresses circumstances where a specific rule hasn't been provided for in the criminal code for remote appearances, and again requires the consent of the accused or the offender, because it may apply to circumstances post-conviction, and is drawn from existing section 715.23. And then I think the provision that has come up, proposed section 715.241, again drawn from section 537(1)K, section 650, and finally sections 715.242 and 715.243, drawn from existing provisions 715.24, 537, and so on. So to summarize again, the proposals really do seek to consolidate a number of different provisions that already exist, do not propose to change the requirements, and builds in the checks and balances for when remote proceedings would be possible. Thank you.
Thank you. Mr. Moore?
Thanks, Mr. Chair. A couple things. I mean, I certainly appreciate the testimony that we're hearing now on this, and we understand. But we also heard during our victim study how consent of the defense and the prosecution, oftentimes victims are the ones that are, are on the sideline, and they don't have as much say in the process as some may wish to believe. And it's only after going through the process that they realize how much this is out of their hands. We know that there has not been extensive consultation with victims groups on this. My concern is I'm dealing with a particular case in my riding now. We're on a parole hearing where the victim's family has to participate virtually, and that creates a hardship for them. It's not something they wish to have happen, but it's happening nonetheless. With all that said, I think in the interest of time, I heard Mr. Garrison say the magic words that he's inclined not to support any of the amendments. So maybe, Mr. Chair, I think we all know where we stand on it. Maybe in the interest of time, we'll just get to the voting part unless Gary has something to indicate he'd be open to any of the amendments. I think my quick math tells me we could just get to the voting.
Thank you, Mr. Moore. And now, I guess, seeing no more speakers, we'll go, shall Block 1 amendment carry?
Yeah.
No. So my quick math, I believe the amendment is defeated. Shall Clause 39 carry? Yes.
On division.
On division. Colleagues, could we regroup Clause 40 to 45 on one vote and then go to Clause 46? Do I have unanimous
Yes.
consent? Yes. Okay, so they shall carry? Yes. Okay.
Yeah.
Clause 46, we have Bloc Québécois Amendment 2. And I just want to note that if this is adopted, we cannot move to Conservative Amendment 1 because of a line conflict. And House of Commons Procedure and Practice, 3rd edition, states on page 769, once a line of a clause has been amended by the committee, it cannot be further amended by a subsequent amendment, as a given line may be amended only once. Although we kind of know the outcome of this, so but we'll still put it to a vote. So Bloc Amendment 2, shall we carry? No, no. So we have, it does not carry. Conservative Amendment 1 it was defeated, so we can go forward to it. Does anyone want to speak to that, or should we just go to the vote?
Mr. Chair, I explained the reasons for Conservative Amendment 1 when I spoke earlier. So, I would move Conservative Amendment 1.
Okay, thank you. Shall Conservative Amendment 1 carry? So no.
Yes.
No, no. So I think it's defeated. Shall Conservative Amendment 2 carry?
Yes.
Mr. Garrison is looking at you. No, no. So it does not carry. Block Amendment 3. Shall Block Amendment 3 carry?
Si vous permettez, Monsieur le Président, je voudrais...
Chair, I would like to intervene and speak to this one. This amendment deals with another aspect of the problem. We see here that the accused, who is not represented by counsel, should have the possibility of communicating in private with a lawyer. That's important. That deals with the discussion that we had on 715.41. I think this is an addition that really should be considered, Mr. Chair. It is page 22, 715.243, in which you would add this phrase that the accused should have the possibility of communicating in private with counsel. I think it's necessary to protect the rights of the accused.
Okay, I don't see anyone's hands up. So shall Block Amendment 3 carry?
Oui.
Okay, so it's defeated. Shall clause 46 carry?
On division.
On division, carried. Again, colleagues, could we regroup clause 47 to 79 for one vote?
Yes.
Yes. Okay,
Yes.
shall they all carry? Yes.
Yes.
Okay. Shall the title carry? Yes. Shall the bill, and it wasn't amended, right? So shall the bill carry?
Oui.
Shall the chair report the bill to the House? Okay. Perfect. So now we will suspend for a few quick minutes. Hopefully we'll do this in the next 1 or 2 minutes for our second review of the draft report on the subject matter of Bill C-28. Thank you. you.